Muted. Just want to make sure.
Let's get through this. Do you have any slides with audio? Okay, that's fine then. Yeah. Great. Yeah. You want me to see the room? Well, it's coming through the laptop right now.
Okay, it doesn't matter.
No?
Yeah.
Okay.
Okay, so let me use that. Should I go? Yeah. Okay. Great. Okay. Sorry, y'all. Thank you for bearing with us. Thanks for coming to our panel. We're going to be discussing next steps in the fight against offshore oil and gas development. My name is Kristen Monsell. I'm an attorney in the Oceans Program at the Center for Biological Diversity, and my co-panelists are Irene Gutierrez with the NRDC, and it's too long to say the full name, and Chris Eaton joining us remotely with Earth Justice. And just to give you a little brief overview of the panel, I'm going to be discussing sort of the scope and some impacts of offshore oil and gas activity in federal waters. Chris is going to be giving an overview of OXLA, the Outer Continental Shelf Lands Act, which is the statute that governs offshore oil and gas activity in federal waters, as well as discussing some recent litigation we've been bringing to fight the expansion of offshore oil and gas activity. And then Irene is going to be discussing fighting the next iteration of the 5-year plan, which you'll learn what that is through this presentation, and also the Inflation Reduction Act and how that impacts these fights. Uh-oh, how do I change the slides? Oh, okay, you're good point. Next slide, please, Chris. Okay, thank you. So as you probably know, oil and gas companies have been drilling our ocean for decades, and the activity is managed under the Outer Continental Shelf Lands Act, or OXLA, and there's two agencies that have jurisdiction over oil and gas activity in federal waters. One is the Bureau of Ocean Energy Management, who oversees leasing, exploration, and development, and then the Bureau of Safety and Environmental Enforcement, who oversees safety and environmental enforcement and also issues permits to drill. And for planning purposes, the Outer Continental Shelf is divided into all of these different planning areas that you can see on your map there. But there's only existing oil and gas activity in a few of these areas. One is off Southern California, another is in Alaska, both in Cook Inlet and in the Arctic, and then also the Gulf of Mexico. Next slide, please. And this is a map of the active leases in the Gulf of Mexico. The vast majority of oil production comes from the Gulf of Mexico with respect to federal waters. There's currently about 2,100 active leases across 11.2 million acres, and that comes with thousands of wells, pipelines, and platforms. And to put some more specific numbers on it, BOEM has estimated that each offshore lease sale in the Gulf will result in up to 1,751 new wells, up to 280 new production structures, and up to more than 2,100 kilometers of new pipelines. And that each new sale will result in the production of up to 1.1 billion barrels of oil and 4.4 trillion cubic feet of gas. Next slide, please. And with this level of activity, obviously comes a lot of harms to the marine environment, to wildlife, to communities, and our climate. The Gulf of Mexico has seen spill after spill after spill, both catastrophic spills like the Deepwater Horizon disaster, and then just a series of regular spills as well. And they obviously can wreak havoc on the ocean environment. You kill everything from phytoplankton to large whales, and can harm fisheries and other people who rely on the ocean environment. Also really harmful impacts to endangered species. That whale that you see there is a newly discovered whale, formerly known as the Gulf of Mexico Brutus whale, but now known as the Rice's whale. It lives only in the Gulf of Mexico in that blue area on that map up there. It's one of the most endangered animals in the world. There's only about 50 of them left, and the National Marine Fisheries Service has found that oil and gas activity in the Gulf of Mexico is jeopardizing their survival and recovery, but nevertheless is continuing to permit activity in its habitat areas. And these whales are threatened by all stages of offshore oil and gas development, from the seismic airgun blasting that companies do to find out where the oil is below the seafloor, to other noise pollution that disrupts its essential behaviors, and also threatened by oil spills. It's estimated that the Deepwater Horizon spill killed over 20% of the entire population and has impeded its ability to successfully reproduce. And they also get run over and killed by vessels associated with oil and gas development. So the list just goes on and on there in terms of harmful impacts. Next slide, please. Offshore oil and gas development also has an extensive amount of infrastructure onshore, which includes hundreds of refineries, gas processing plants, petrochemical plants, and these are located in primarily communities of color, and these plants are sickening and killing these communities, many of whom are also already suffering the impacts of climate change through sea level rise, erosion, and increased storm severity. And we saw, in recent storms that a lot of these facilities had accidents, spills, leaks, and things like that. Next slide, please. Now to take us the other side of the country, Alaska also has oil and gas development. There are 6 active leases in the Arctic Ocean across 21,000 acres. 3 of those leases are producing. And then also in Cook Inlet, further south, there's 14 active leases there in those green areas that you can see across 76,000 acres, none of which are currently producing. Next slide, please. And like any oil development anywhere, the risk of oil spills is a significant concern, but even more so in places like the Arctic Ocean and Cook Inlet, because of extensive amounts of sea ice. Weather is very, very harsh there. It's often dark, so it just makes an inherently dangerous practice even more so. It also threatens Cook Inlet beluga whales. They only live in Cook Inlet. There's less than 280 of them left, so also critically endangered and highly impacted by the noise pollution generated by these activities. And to add sort of another horrible wrinkle, the only current operator in Cook Inlet in state waters, who is the only oil company that has leases in federal waters but hasn't yet acted on them, has a horrible track record of spills and accidents, to the point where the State Oil and Gas Commission in Alaska said that, quote, "The disregard for regulatory compliance is endemic to Hilcorp's approach in its Alaska operations," and virtually assured the violations that they have had over several years in Alaska. And they've also had some instances where workers nearly died, and it was just pure luck, according to the State Oil and Gas Commission, that no one actually died. So it just is, another example of how a very dangerous situation is made even more dangerous. Next slide, please. Now, a little closer to where we are now, the oil and gas activity off California is primarily in the Santa Barbara Channel. There's also some oil and gas activity off the LA area. There are 30 active leases across 152,000 acres. 30 of the leases are, all 30 leases are producing from 23 platforms. Next slide, please. And like, like other areas, oil spills are a huge concern. Again, even more so perhaps because the platforms were installed when these guys were presidents. So the infrastructure has been out there for decades and is well past the life or the age that scientists say significantly increase the risk of oil spills. And we've already seen that. Those photos in the middle there are of the Plains All-American Pipeline, which is actually a coastal pipeline that was used to move oil from some offshore platforms in federal waters, and it ruptured and spilled and was severely corroded. So, I mean, this are all the reasons why we fight offshore oil and gas development. And I'll stop there and transition to you, Chris.
Thanks. Can you guys hear me okay?
Yes.
Okay. Cool. Well, I'm going to give an overview, like Kristen said, about the Outer Continental Shelf Lands Act, or OXLA, as we call it, which is kind of important to understand how we got here and what's next. So the OXLA was first enacted in 1953 to govern how the government grants rights in the Outer Continental Shelf. And the Outer Continental Shelf is basically, for the most part, everything from 3 miles from shore out. Everything within three miles is typically state waters. The act was significantly amended in 1978, and now it came in the context of national oil shortages, and so there was a real push to be expanding domestic production of oil and gas. And so the act is kind of written with some troublesome language about expeditious development of oil and gas resources. But at the time, Congress still cared about the environment, so it includes some language in there that balances the development concerns with environmental impacts, and tries to not just kind of an all-out sale and development without consideration of the environment. So OXLA establishes basically this 4-stage process where you get from leasing to development. So first, you have a 5-year leasing program, followed by a lease sale stage, exploration plan stage, and development and production plan stage. So at the 5-year leasing program stage, Interior develops they propose the lease sales to be held over the next 5 years. Basically the number, where they're going to be, how big they're going to be. And these are just proposals. And that is developed based on considering various environmental concerns, economics, use conflicts. And in the past, typically those sales in the Gulf of Mexico have been focused on just particular portions of the Gulf. And then the Obama administration actually changed that practice to propose lease sales in the entire unleased portion of the Western and Central Gulf of Mexico, with 2 sales per year. So the most recent program was 2017 to 2022, and that obviously expired last year, and Irene will talk about the next program. The lease sale stage is where BOEM makes the decision about whether to hold the sales that were proposed, how much to offer, and where, and what lease stipulations to put in. And so you kind of think of it as a pyramid. 5-year leasing program establishes the outer bounds, like the most that can be leased. So you cannot hold lease sales that are not in the program. but you can decide to cancel sales that are in the program, make them a lot smaller than they were proposed. So you can shrink. And you may have heard earlier, I guess last year, 2 years ago, the Biden administration paused new leasing, and there was a bunch of states, Louisiana filed a lawsuit against that pause and got a preliminary injunction against the lease pause. And one of the arguments in that case was that if a sale is proposed in a 5-year leasing program, Interior is required to have it. They can't cancel it, they can't delay it, they can't shrink it. And the Western District of Louisiana judge bought that argument and basically said, if it's in the 5-year program, you have to have it, which is, you know, a problem because that is in direct conflict with the statute and DC Circuit law. Anyway, we can, if you have questions about that, we can talk about that. And then once leases are issued, BOEM is kind of somewhat limited in the degree to which it can restrict development on the leases, but it does have some options. So then we move to the exploration plan stage, and that's where lessees apply for approval to conduct either what are kind of seismic surveys, basically where they you use these seismic ships to get a characterize what the geology is under the seafloor, see where the oil is, and to do exploratory drilling. And BOEM can deny a plan if it will probably cause serious harm or damage to the environment, and they can also impose conditions of approval to limit harm to the environment. After the exploration plan stage, you get to the development and production plan stage, which is where lessees who have explored now get a approval to develop wells and start pumping oil out. And again, BOEM can deny those plans if they're kind of exceptional environmental concerns, but otherwise just have kind of typically just have the authority to impose conditions of approval. So what are our legal options to challenge these? Well, our old friend NEPA theoretically applies to all of these stages. So BOEM will do a programmatic EIS at the program stage. Then for individual leases, they'll do a lease specific EIS. And the reason there are question marks next to the exploration plan and development plan stages is because BOEM has a categorical exclusion that they typically apply to these plans, meaning they don't do new NEPA. They basically say drilling wells, developing wells will not have typically do not have significant impact on the environment, so we don't need to do NEPA. For example, BOEM applied that categorical exclusion for the approval for the Deepwater Horizon rig, which we know obviously had a significant impact on the environment. Let's see here. So Krista mentioned that we've been engaged in some litigation over these, and about 6 years ago, we kind of decided that Earth Justice and our partners have decided that the best way to get at Gulf drilling is at the lease sale stage. There's some bad case law about kind of ripeness issues where it's hard to challenge the 5-year program, but you can challenge lease sales. And so we brought a first set of challenges to lease sales that were held in 2018. And again, NEPA was the hook we used. We brought basically three claims. One was challenging their no action alternative, where BOEM basically their no action alternative said, if we do not hold a lease sale, we assume that we will still hold the same sale again in the future. And so if we don't hold it now, it's going to have no reduction in environmental impacts. And so we challenged that as arbitrary. We also challenged some assumptions where for oil spill risk, BOEM was saying, one, that sister agency, Bureau of Safety and Environmental Enforcement, is doing a great job of enforcing the laws to reduce oil spill risk. And two, the Obama administration issued these offshore drilling safety regulations that are going to be doing a great job of preventing oil spill risk. Problem with that is there was evidence, a Government Accountability Office report saying that the Bureau of Safety and Environmental Enforcement actually was doing a terrible job of enforcing safety regulations and creating a serious risk of spill. And two, the Trump administration was in the process of repealing the safety regulations. So we argue you cannot rely on BSEE's enforcement and these safety regulations that are not going to do a good job to say there's not going to be any oil spills. While that case is pending, BOEM kept issuing new leases, and so we have a companion case. We challenged the lease sales as they came out under the same claims. In April 2020, the district court ruled against us across the board and basically said BOEM did their best. And so we appealed to DC Circuit, and last August, the court, in an opinion by Judge Katsas, ruled for us on the Government Accountability Office enforcement argument. Basically said, yeah, there's this evidence before the agency that BSEE is not doing a good job on safety, and you can't rely on that in your NEPA analysis. The circuit affirmed the district court on other claims, which is kind of a shame. During oral argument, Judge Ketanji Brown Jackson was on our panel and seemed very receptive to a lot of our other arguments. But then she went to the Supreme Court before the case was decided, and so left us in the hands of a Trump judge to issue the opinion. The opinion kind of continued this troublesome NEPA trend where the court remanded the lease sale without vacating it. And so in the meantime, a new GAO report came out that said, okay, BSEE has now fixed their enforcement problems. They're doing a good job. And so on remand, BOEM put together a new supplemental environmental impact statement for future sales that basically said, it's all good, that we're gonna have great enforcement. We have no oil spill risk. So kind of the upshot of this is, yeah, we won the case, but the case is about to be closed now. And the end result is that the leases that were sold in 2018 and 2019 and 2020 are still in place. So mentioned the lease pause case, which brings us to the second litigation, Friends of the Earth v. Holland. So after that preliminary injunction, the Biden administration got scared and decided to hold a massive lease sale in the Gulf of Mexico in November 2021, and claimed that the Louisiana preliminary injunction required the sale, which is false. And in fact, the government argued in Louisiana that the preliminary injunction did not require the sale. And so anyway, they didn't need to hold the sale, they did. And we were ready because we knew that they were going to rely on the same environmental impact statement as the previous leases. So we had a complaint ready to file, filed it the day that the sale was formally scheduled. Brought several claims, but the important one here is a claim about a faulty greenhouse gas analysis that both the Ninth Circuit and District Court of Alaska had found to be arbitrary in other cases. And basically what BOEM did is in analyzing the greenhouse gas emissions that would result from a lease sale, they said if we don't hold a lease sale in the Gulf, then we're going to need that oil from somewhere, and so it's going to be imported from other countries. And so assumed that if we don't hold a Gulf lease sale, it's going to increase emissions because importing oil from other countries requires transportation emissions. So it's actually better to lease in the Gulf than it is to not for climate, which we know is false. And one of the problems with their analysis is that if it's true that we're going to import foreign oil, then that foreign oil is not available for foreign consumption. So foreign consumption is going to decrease, meaning worldwide greenhouse gas emissions will actually go down. And so BOEM assumed that worldwide emissions would stay the same. And that's the analysis that the United Circuit and District Court of Alaska had already declared arbitrary. And so we brought that same claim, and we won. We moved the case on an expedited schedule because we the problem of getting a lease sale vacated after leases are issued is on NEPA grounds is tough. So we moved it quickly to get a decision before the leases were actually issued. Court ruled for us on greenhouse gas emissions. One thing that argument that came up that probably several of you have confronted is the shell game argument. The defendants, the government, and interveners argued it's not appropriate to consider greenhouse gas emissions at the lease sale stage because you don't know which of the leases are going to be developed yet. There's not enough information yet. You need to wait until you actually have development plans in place to know the leases are going to be developed before you can consider emissions. And fortunately, you know, the problem with that is you get segmentation, right? So you look at greenhouse gas emissions from any one given drilling project are going to be relatively small in the scheme of things. But if you look at greenhouse gas emissions from all the development of leases in the sale, that's large. And so the court agreed with us, basically said that it is really important to understand how many emissions you're going to get from a lease sale for the agency to understand that, to make that decision and decide how much to lease. And so court ruled for us, vacated the sale, and the leases had not issued yet, so that meant no one could get the leases. Industry and state of Louisiana appealed, intervened. They were interveners in the case, and that's its own saga because of the Inflation Reduction Act that Irene will discuss. But just for purpose here, that case has been briefed. We're waiting for the DC Circuit to issue a ruling there. So what have we learned from litigation? We've learned that NEPA can be an effective tool in the fight to stop new leasing, but it has its limits. So namely, kind of the remand without vacatur problem, where you may win, but ultimately industry still gets their leases. And another problem is that, you know, you win a NEPA case, agency goes back, patches over the error that you identified. Eventually they'll do a good enough job, and you've got to find new hooks on NEPA if you want to keep litigating. So I will leave it there and turn it over to Irene.
Awesome. Thanks for coming, you all. This is a really exciting time in oil and gas work in the US. And so I'm glad that we get a chance to talk to you all about it. So the thing that I wanted to talk to you about is the 5-year program and the Inflation Reduction Act. Chris, could you move us to the next slide? So thinking back to the schema that Chris set out earlier, one of the key pieces of BOEM's oil and gas leasing regime is the national OCS leasing program. And what this is that every 5 years, BOEM issues a plan that sets out the schedule for oil and gas lease sales across the United States. Typically, in ordinary years, this is focused on Alaska and on the Gulf of Mexico. We did see during the Trump years a proposed plan that included leasing all across the coast in the United States, and that was very, very alarming. And environmental activists have focused on advocacy to shape this program for a couple of reasons. If you think back to that diagram that Chris laid out, this is sort of the key for leasing in the US, offshore leasing in the US every 5 years. So if you can shape what that plan looks like, potentially you could have a plan that has fewer lease sales or even a plan with no lease sales. There are a couple of things that the Department of Interior needs to consider when designing this plan. So they're tasked by the Outer Continental OXLA, and we put the statutory site there so that you can take a deeper look at the statute if you want to. But BOEM has to design a plan that best meets national energy needs, and they need to consider various factors when designing this plan. Again, they're in that statute, and you can take a closer look there, but they need to consider economic factors, social and environmental values, impacts on other resources of the Outer Continental Shelf, as well as impacts on coastal and human environments. They also need to look at how risks and benefits shake out to different communities affected by oil and gas drilling. And they need to look at the effects on other industries like the fishing industry or the shipping industry. They need to think about the balance between environmental damage and the potential for discovering oil and gas resources, as well as adverse impacts on the coastal zone. And they need to think about what counts as a fair market value to the American public. So there's a lot of things that they need to think about. I guess, so Interior proposed a program following the Louisiana lease pause case. And this diagram up there shows that they basically followed business as usual. So they proposed a program that included 10 lease sales in the Gulf of Mexico and 1 lease sale in Cook Inlet, Alaska. So just taking a step back for a second, I think the Biden administration has faced a lot of challenges implementing the bold climate agenda that the administration came into office with. They said they wanted to do a lot of bold, innovative things when it came to fighting climate change, but they've been faced with industry lawsuits and they've been faced with public pressure from industry groups. And so we see something like this, which is the same as what Obama did, not too dissimilar from what past administrations have done either. This has been the source of a lot of advocacy over the last year by folks that do offshore oil and gas work. So all of our groups and many other groups around the country submitted comments criticizing this proposed program and pushing for BOEM to use the authority it has to do something different. As Chris mentioned, OXLA, OXLA both directs the development of oil and gas resources, but it also gives the Department of Interior a lot of power to consider environmental considerations, social considerations, and we've been pressing them to use that inherent authority to take some bold measures and do something that is more environmentally protective than it's done in the past. In the CLE materials for this program, we have, I'm not sure actually the best way to access this, but if you're curious about what we said in our comments, they are in the CLE materials for this, this particular talk, but I can summarize some of the main arguments that we raised in those comments. One of the arguments that folks have raised is that, the energy landscape is transforming. We live in a time where demand for US energy, for US petroleum is going down. Cars are becoming more efficient, homes are becoming more energy efficient, commercial buildings are becoming more energy efficient. So we're in an energy environment where consumer demand is going like this. And we're also in a situation where oil and gas companies are sitting on a lot of untapped leases. And we also, just as a nation, have a lot of energy in reserve already. And various analysts have looked at this, and according to some metrics, we have enough energy to meet US needs for the next 10 years. So, the energy landscape that we're in is one where ideally we'll need less and less fossil fuel resources as time goes on. And BOEM has the ability to take that information and shape a plan that doesn't aggressively pursue leasing in the way that it has done in the past. Another line of argument that we made in our comments on the proposed program is that the ecosystem harms of continuing business as usual outweigh the benefits of oil and gas drilling. As Kristen mentioned, there is a severely endangered whale in the Gulf of Mexico, Rice's whale. It just really, further industrial development is really going to harm this species, and we don't want that in the Gulf. We also have an environment that continues to be impacted by the effects from Deepwater Horizon, which happened more than a decade ago. It's still recovering in so many ways from that disaster. The earlier slide that we showed some of the onshore infrastructure that the Gulf of Mexico is grappling with. We also have a lot of communities in the Gulf region that have disproportionate health burdens because of the massive amount of fossil fuel infrastructure that's in place. And maybe just to share how big of a refining hub the Gulf of Mexico is. The offshore reserves produce about 15% of the nation's oil and gas supply, and about 50% of the nation's refining and petrochemical capacity is there. I've done a little bit of, I've been to the region, maybe you've been to the region as well, Kristen, I think Chris has as well. It's just really striking to drive around. So for miles and miles, you just see these giant refinery complexes, and there are towns right next to them and residences right next to them. And so there are a ton of community harms that the region faces from continued oil and gas development. I guess finally, we also made a set of arguments talking about how fair market value doesn't just require selling off public waters for continued development. There is a value to keeping ecosystems healthy and keeping communities safe. And we also just need to see how energy policy and energy needs play out over time. So we should see a decision sometime this year. The current plan expires in 2023. So BOEM has an incentive to put out the next version of the plan in order to continue their leasing program. So we'll see what they do with all the information that we've given them. Chris, could you send us to the next slide? Okay, so as you probably know, I mean, this was a big deal for the Biden administration. There was a lot of celebration about this. There was an act that passed earlier in 2022, the Inflation Reduction Act. There were a number of good things that this act did. It provided a lot of money for investments in clean energy infrastructure, in the development of renewable energy resources like solar and wind power. It gave a lot of money to transportation electrification. And there were a number of things that were very bad in it for folks that work on onshore and offshore oil and gas issues. So I'm going to spend a little bit of time talking about that. One of the things that well, I guess, I don't know, there is a sense that these concessions were made to appease Joe Manchin, who is one of the key Democrats needed for the passage of this act. So I think that, I'm not sure, I mean, this is a very obvious takeaway, but Joe Manchin is somebody who is a challenge to getting good legislation passed. And there are times when the compromises needed to pass legislation come at a severe cost to the environment. And I think that this is one sector where we have really seen those concessions and costs come to light, and that creates serious challenges for environmental advocates. So as Chris mentioned, the Biden administration came into office, and one of the things that they first did was to put a pause on onshore and offshore oil and gas leasing. There was litigation over that. A Trump-appointed judge in the Western District of Louisiana ended up overturning that executive order. And the way that the government chose to implement that was to continue with their leasing program, and IRA sort of reinforced that direction. The Inflation Reduction Act mandated that for lease sales that had been either paused or canceled previously be reinstated. So these are the various lease sales. 3 of them are in the Gulf of Mexico. 1 is in Cook Inlet, Alaska. The Cook Inlet, Alaska sale is something that our groups are challenging in court. That's in the very early stages still, so we'll see how that shakes out. Another lease sale is also in litigation. That's lease sale 257, and that particular case is up on appeal. And then we have these 2 other lease sales, one scheduled for March and one scheduled for September of this year. So we'll see what happens as time goes on. Chris, could you take us to the next slide? The other, and I've heard people describe this as a diabolical provision, and I think it's really true. There is this other provision of the Inflation Reduction Act that makes continued wind leasing contingent on continued oil and gas development. And some of the key provisions of this particular clause in IRA is that it requires an oil and gas lease sale of 60 million acres be held. It requires that if any acceptable bids are received, that at least one lease be issued, one oil and gas lease be issued. And these criteria need to be met every year that the government wishes to issue new offshore wind leases. So that's a really challenging provision to deal with. A number of the organizations that are on this panel, and then also other organizations, do some mix of work to fight dirty energy development and also promote clean energy development. So this is something that our groups all are going to have to contend with. You know, how do we move off dirty energy and move towards clean energy? And Joe Manchin has given us a lot of food for thought and thrown a very serious spanner into the works. Could we go to the next slide? I guess this is just a visual summary. So in order to get to wind energy turbines, we need to surmount the risks of further disasters like Deepwater Horizon. Very open to ideas about how to do this. We've been doing a lot of thinking about the best way. Okay, final slide, and then we can move into a discussion section. So just to recap what's coming down the pipeline, there's that lease sale 258 case that is where litigation is underway, and we'll see how that shakes out. There are the Gulf lease sales, one in March, one in September. There is the next 5-year program, which we expect to see sometime this year, and then just continuing to grapple with the legacy of the Inflation Reduction Act and how that has linked wind and gas development. So that is the presentation. We had a couple of topics for discussion, but maybe we can have a panel discussion and then move into audience questions. Chris, do you want to kick us off?
Sure. Can you guys see me okay?
Yeah.
Cool. I cannot see you. I just see a window. But yeah, I can go ahead and kick us off. Yeah, I think you know, one question that we can talk about, you know, if the Biden administration, if BOEM is going to keep holding lease sales, is there anything that can be done to minimize the acreage of the leases that are being sold or issued and the impacts? And maybe we can kind of start by talking about that.
Yeah, I mean, I guess I could go first. So I think that yes is the short answer to your question. I think the longer one is that while the Inflation Reduction Act mandates that the Biden administration hold particular sales, it didn't take away any of their broad discretion under OXLA to ensure environmental safeguards are in place, to ensure that, you know, there's a balance between development and between oil development and protection of the environment. And in fact, the Inflation Reduction Act, you know, references the record of decision for the prior 5-year program, and that record of decision specifically contemplates that BOEM can adopt mitigation measures at the lease sale stage. And you know, we're urging it to do so by, for example, excluding Rice's whale habitat from availability for leasing, which they did for offshore wind, but did not do for oil and gas development, which is just infuriating, but I think is probably a testament to the power of the oil and gas industry, particularly in the Gulf of Mexico. And or, you know, exclude other important habitat areas, or include lease sale stipulations that restrict the overall amount of development that's allowed under any leases, or, you know, include terms that essentially will phase out that new oil and gas extraction. So they in some, I guess, they still have a lot of discretion. We're urging them to use that discretion to include conditions that will best protect the environment. It's been really frustrating to see, you know, the Biden administration, who claims to care about the climate crisis, the environmental justice, and the extinction crisis, but take this very, very narrow view of their obligations, and just use the excuse of the Inflation Reduction Act to not do more.
Yeah, I guess I agree with all of those things. Also, we'll just underscore that even after the Inflation Reduction Act, the Biden administration still needs to follow NEPA and other environmental laws. It does not give them free pass to do anything they want to do, or a free pass to continue oil and gas development without the required environmental review and scrutiny. So that is something that our organizations are very much committed to keeping the Biden administration accountable to, is following NEPA and following other applicable laws, in addition to using the discretion they have to curtail the size and scope of oil and gas development.
I think, one of the things that's been frustrating is that, the Biden administration has this discretion to not lease like the most possible, and they keep doing like, we're going to keep doing the most possible. And we keep urging them, like, you've got discretion to do less. You've got discretion to do various things that can be helpful for the environment. And one of the, like some of that is the argument, like, you guys have got to get a little bit creative, not creative in a way that runs afoul of the law, but think about that discretion differently. And one of the things that we've been talking about and ideas we've been putting out there is with regard to the discretion to accept bids. So they can hold these lease sales, industry can bid on all of these acres, and OXLA and BOEM's regulations say BOEM can just choose not to accept those bids for basically any reason. And a good reason to not accept the bids is the climate crisis. So one idea that a coalition of us have developed is to apply kind of a climate screen. So when BOEM holds a lease sale in the Gulf of Mexico, they should know, how much oil can we be taking out of the Gulf and still meet our climate commitments, and figure out, what's that cap, and say, we're not going to accept bids that are going to push us over that cap. And again, this is going to require some creative thinking on the administration's part, or not creative thinking, courage. We'll see if they go there. I think they do have some options.
Yeah, and we're also doing that for the recent Cook Inlet lease sale 258. There was one bid on one track, and it was by Offshore, that company that has a horrible track record that I was talking about. So we're urging the administration to not accept that bid, because we haven't really focused on the climate change aspect for that one, but more so on the fact that you have this incredibly bad actor and they shouldn't be rewarded with more leases offshore, and also this new information about Cook Inlet belugas that they're doing even worse than they thought at the time of the sale, which was just a few months ago. So see what happens with that. But yeah, as Chris mentioned, they just have this really broad discretion to not accept it.
Chris, and that reminds me of the other the fitness to operate standards. So basically, it's these standards where BOEM can restrict who is allowed, what companies are allowed to bid on leases. And traditionally, they've kind of thought about it, or this is one of the recommendations that came out of there, is Interior had a fossil fuel leasing review a couple years ago now, and one thing that came out of it was to increase, kind of basically set somewhat higher standards of fitness to operate. You've got I don't think we talked about this, but decommissioning is a big problem in the Gulf of Mexico, where you've got companies that they go develop these leases, and then often it starts with like BP or Shell, like one of the big companies, and then we'll sell the lease to these smaller companies that lack financial resources, don't do a great job complying with environmental and safety standards. And then those companies, when it's time to, they're done drilling, time to pick up your stuff, plug your wells, they're like, oh, we don't have the money. And so you have a lot of these infrastructure and potentially leaky wells in the Gulf of Mexico. So one thing with the fitness to operate is basically setting standards of, if you want to own a lease in the Gulf, you've got to show that you're going to take care of it and you're going to clean up your mess. But there can be other standards that go into that. So like a 3 strikes rule sort of thing on if you're spilling a bunch of oil, if you've got worker safety problems, if you know, and basically raising the bar so that we're you know, it is only companies that are actually going to, you know, take care of the environment, if you will. Not that these are like great environmental actors, but, you know, weeding out the ones that are the worst for the environment so that they're not buying leases, I think is something that we can push for.
Chris, I see an audience question. So should we take some time for audience questions and we can
Yeah.
points? What was your question?
Yeah, so I know in the quest for stopping oil and gas exploration as well as just stopping oil and gas in a whole, that there's been, especially more recently, some arguments back about the war in Ukraine and the need to meet energy elsewhere. And so my question is really, how do you combat those types of narratives, other than like the obvious, how long it takes to get some of these projects online?
Yeah, some of it is you know, research that various of our groups have done showing that we have a lot of energy reserves already, and we also have sources of domestic renewable energy. So we don't need to continue, you know, there is something of a false narrative. The war in Ukraine will turn off the taps for critical energy supplies in the US. I don't think that's actually true. We have energy here that's sufficient to meet our needs for a while, and we don't necessarily need the energy that's coming from Ukraine. Of course, it is something that politicians and lawmakers are concerned about because it's a big global crisis, and it does have implications for the price of energy in Europe for sure, and in the US in some degree. But I don't think that whatever happens there is determinative for what the price of energy in the US is. Do folks have other info that?
Yeah, I mean, I think the point about you know, these projects taking a long time to come online is a really important one. You know, in the Gulf of Mexico, about last I checked, I think 78% of acreage that's under lease has not yet been developed. And so you've got these oil companies who are saying, like, I think it's important to like look at the frame of whether you're talking about leasing or development of leases. So here you've got these companies that are saying we need a lot more leasing because of Ukraine. But what we know is you've got millions of acres already under lease that you're not developing. So if if your complaint is that we need to be drilling for more oil in the US, like, not saying that we want you to do that, but you can do that. Like, you've got plenty of opportunity to do it. You don't need new leases to do that. And so, you know, it's just kind of a false narrative that we need to have more leasing. And in the Gulf, kind of on average, it's about 10 years after a lease is sold before any oil comes out of it. So, you know, the leases that are going to be, lease sales that are going to be held later this month, you know, 2033, before you get oil from there. And you saw that slide with offshore wind development, wind sales that are going in, renewable development, kind of the surge in you know, sales of electric vehicles. Like, in 2033, how much oil are we going to need? Should be a lot less than we need now, hopefully. So you know, the trying to get more leases based on, you know, the crisis of today is kind of just a totally false narrative.
Yeah, and I don't think I have anything more to add to that other than like what is really, I think, more of a talking point that like it's just all the more reason why we need to get off people so we're not relying on horrible tyrants. Hi, I was curious about the safe part that you talked about, the divided answers for your expressions that so some of those seem like maybe they're hypothetical. I was wondering if you could talk more about that. Have you actually seen the vitamin?
Yeah, so I mean, some of them folks on the panel have talked about, you know, like leases are basically contracts between the federal government and operators. So the federal government can put whatever, maybe not whatever it wants into that contract, but it has a lot of discretion to set the terms of what leasing and development look like. Things that we've seen recently, actually, so for the government announced that it's going to have the March lease sale on March 29th, and they've said some of the conditions they want that lease sale to look like. Among them are, they've sort of shifted the bounds of what they're going to lease. So they've excluded, sensitive ocean features from the lease sale, like seamounts, and other sensitive areas that have sensitive benthic habitat. So that's one thing that we've seen them do. And yeah, they have discretion to do more for sure. They could put more stringent conditions on how wells are operated once they're actually in production. And then they could shrink the size of areas, put other restrictions in place.
Yeah, and this isn't a Biden administration specific thing, but so for example, the existing biological opinion for offshore oil and gas development in the Gulf of Mexico that was issued by the National Marine Fisheries Service, because it was a jeopardy opinion for racist whales, they issued completely inadequate, reasonable, prudent alternatives. So now these stipulations for any new leases have a requirement in them that they have to comply with the RPAs in the biological opinion, which are just that any oil and gas related vessels have to travel no more than 10 knots or less when they're going through that the eastern part, but only the eastern part of it, because I think I neglected to say this, but the western part of that sort of horseshoe is newly discovered habitat for the whale. Everyone originally thought that they were just now confined to this small strip, but new science says that their habitat is much more expansive, and so they're overlapping with a lot more oil and gas activity than was originally thought. So they have to, if they're going through the eastern part, they have to travel 10 miles or less. Or if it's at night, avoid the area to reduce the risk of dust strikes. But that's just one of many threats of oil and gas.
Yeah, it was a good segue, because I was going to ask about using the endangered staff and marine mammal protection act, and it sounds like the challenge when they do come up with a jeopardy opinion, but I guess first of all, have you been able to give any success stories of those, and also any reinitiations of consultation?
Hopefully a success story soon. We're litigating the oil and gas buyout for the Gulf of Mexico, and a bunch of different claims in that case, but the agencies have reinitiated consultation and filed a motion for voluntary remand, and so we're fighting that. So it's sort of TBD what's going to happen. Chris is doing the heavy lifting on that case, so I don't know if you want to add anything.
Yeah, and not to like go down a side road about voluntary remand, but we had filed our summary judgment brief, and then the government said we've reinitiated, we should voluntarily remand it to us for at least 2 years, and basically asked the court to kind of function as dismissing the case without reaching the claims, and there'd be no mitigation in the meantime. And we're like, that's BS. Like, you've got this inadequate biological opinion, you shouldn't be allowed to keep using it to authorize oil and gas activity while you've acknowledged that you've got to redo it. So we're fighting about that right now, and I think there are a lot of claims that we brought in that case. One of the big ones is how they basically, this is an ESA problem and a NEPA problem, is that the agencies say that a catastrophic spill on the scale of Deepwater Horizon, or even a catastrophic spill that's like a lot smaller. I mean, what was Exxon Valdez was like 200,000 barrels or something, or a couple 100,000 barrels. Like, they basically said, that is, trust us, like that will never happen again. And so we don't need to consider the impacts of it. And so that's one of our claims is, they submitted statistical analysis that they said shows that there's no chance of this happening again. And we had a statistician look at it who was like, oh no, this analysis basically shows there's like a 40% chance that another Deepwater Horizon spill is going to happen. And like, yeah, that's less than 50%, but like, do we really want to take a 40% chance of another BP? No. So, that's one of the claims, and the agency has said that they've reinitiated to take another look at their oil spill analysis. We don't know what that means, but hopefully it will include a better look at catastrophic spills, because if the agencies are going to assume that a catastrophic spill is going to occur again, and then you look at the effects to the environment, the effects to species, that should create a jeopardy opinion for most of the species that you have in the Gulf, and require a lot stronger mitigation, which may, or mitigation may be, you just can't be authorizing new oil and gas activity. So we'll see.
Yeah, and bringing ESA claims at the lease sale stage is difficult because there's some existing bad case law that says that because there's all these subsequent permitting stages that need to occur, new approvals that the oil companies get before they can actually do any activity, there's no ESA at the lease sale stage. And at least in the Gulf, like, yes, we could challenge the approval of a development and a correction plan. We could challenge the approval of an exploration plan, but under the judicial review provisions of OXO, we would have to do that directly in the Fifth Circuit, which is a horrible circuit to be in. And I think our chances of success would be less than zero, but that's possible. So, and another reason why we targeted leases. The Marine Mammal Protection Act also provides another hook, and that is the statute that protects all marine mammals. And if you're going to do an activity that's going to harm or harass or kill marine mammals, you need to take authorization from either NIST or the Fish and Wildlife Service, depending on the species. And you challenged NMPA regulations in the past in various places, and did have a lawsuit that challenged the failure to do any NMPA authorization for oil and gas activity in the Gulf. And we got some interim mitigation measures in place that was time area exposures like that, but that led to a new rule that we then challenged as insufficient. But the agency is in the process of doing that rule.
I want to stick to the ESA and MMP for a bit. I'm thinking of the incredible scale of Gulf of Mexico, and wondering to what extent incredible scale over a broad geographic area helps or hinders your ESA and PA plans. There's already a ton of noise, but you're also describing really old infrastructure. So how do those different aspects of what's happening in the Gulf in particular less of a concern? Like how you bring such problems?
Yeah, I mean, that's what Philip always says. It's like, well, there's already so much activity, this additional lease sale, this additional permit, this additional development plan isn't going to really make much of a difference in the scheme of things. I think one of the reasons why the BIOP did find jeopardy to Rice's bills is, well, one, because there's 50 of them left, but two, because it looked at all the approvals of all oil and gas activity for the next 50 years in the Gulf of Mexico. So, everything from the exploration, seismic to decommissioning. So the scale of the analysis, I think, helped us there. Also, the fact we had an incredibly endangered species. But often do rely on the fact, particularly in the NEPA analysis, I would say more so than doing data species tax analysis, that like, oh, there's already so much activity. NBD could have more. But and then with the MMPA side of things, they often will kind of bend over backwards to find that whatever activity they're permitting isn't actually going to kill the species at issue. It'll just cause them some harassment. So they'll basically swim away and it'll be fine. But when you're talking about such an incredibly endangered species like the Rice's whale, any impact at all is an impact that's too much. And over 100 scientists have sent a letter to the Biden administration urging them to not approve any seismic activity, not approve any forest gas activity at all in this entire habitat area because of how endangered they are. I don't know if you have any, I don't know if I'm really answering the question, but do you have anything to add to that, Chris?
No, thank you. You covered it.
Right in the space, usually in conversation about the science, this industry, subjective, still like, well, all these are already happening.
Chris, did you?
Sorry, I couldn't quite hear. Could somebody repeat the question?
The question was, are we seeing any attribution science between the level of oil and gas activity that's being permitted with the jeopardy analysis? Is that right? Yes, right. Yeah, and climate change science is like the first thing that comes to mind. There is more and more science coming out that attributes a certain amount of carbon emissions to a certain amount of sea ice loss. And so that's one thing that we're starting to point to as a reason why the agencies need to consider the impacts of increased greenhouse gas emissions on climate-friendly species in particular. I don't know about any other science that is unrelated to climate change that has that attribution, but it would be great if there was some out there. Well, if there are no more questions, I think we're past time. So thanks for coming. And
Thanks, folks.
yeah, sorry about all the tech issues, but
Thanks, everybody.
thanks, Chris.
Thanks, guys.
See you guys. Bye.